9 a.m.
Okay, thank you. Nothing further.
Anything else on behalf of Miss Little?
No, thank you.
Thank you. I'll see you all in January. Have a good afternoon.
All right. Have a great day, everyone.
Ms. Hildreth, your case isn't scheduled until 9:15. My policy is about 15 minutes after the scheduled start time. So if someone from Ms. Winter's office is not present by 9:30, I will call your case. If they get here earlier, we'll get you connected into a breakout room if you'd like to speak, okay? Same to you, Mr. Rogers. Your case isn't scheduled until 9:15. The court's policy is 15 minutes. So if someone's not here from Ms. Smith's office by 9:30 at the absolute latest, I'll call your case and let you get on with your day, okay?
Okay, Your Honor.
Thank you. And Mary Ann, our January civil date is supposed to be the 2nd, but I'm showing us as closed that day. Is that what you're showing on the calendar?
I do not show that on the master calendar.
Oh, that's not good then, because that case should have been scheduled on January 2nd.
I see.
Just
we're
making
closed
updates.
Yeah, we're closed on the 1st.
So it should not be the 9th. It should be the 2nd, and I'm sure their notes will say the 2nd on the 9th, but we'll fix it on our end. That's not good. Why do I think we're closed the 2nd? This is 2300123 GC Portfolio Recovery versus Ronnie Elam. Your appearance, please, sir.
Good morning, Your Honor. Suzanne Barda, P 65425 on behalf of the plaintiff.
Thank you, Mr. Barta. Today is the day and time set for the first pretrial in this matter. Notice was sent to the defendant that he has failed to appear this morning. How would you like to proceed?
Your Honor, I would respectfully request that we would be allowed to submit a default judgment.
The principal and your court cost, sir?
Oh, 1 second, Your Honor, sorry. Let me pull that up. Your Honor, the principal amount is $1,259.79. And I believe we just have two costs. One would be the filing fee of $55 and a service fee of $56.65.
Thank you. Defendant, having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant. Principal damage is $1,259.79. There's $55 filing fee, $56.65 service fee. Have your office submit that default judgment on base, please.
Thank you, Your Honor.
Anything else in this matter, Mr. Barta?
No, ma'am.
I'll see you at 9:30, sir.
Thank you.
Good morning, Mr. Cox.
Good morning.
Do you need to speak to Ms. Hildreth before this case is called?
I'm happy to do so.
Ms. Hildreth, would you like to speak to Mr. Cox before the case is called?
Yeah, that'll be fine.
Let's get you moved into a room. You should see an invitation to go into a room number 1 with him.
Thank you, Judge.
Thank you.
Morning, Mr. Hill.
Good morning.
Are you here for Terry Rogers, Midland Credit versus Terry Rogers?
Yes, I am. I'm covering this today for Midland Credit. So
Do you need a breakout room?
perhaps yes, because
Is that okay, Judge?
Absolutely. Mr. Rogers, would you like to speak to Mr. Hill before this case is called?
Sure, Your Honor.
Thank you. You'll see an invitation to go into room number 2 with him. Please go there.
thank you.
Thank you. Good morning, Mr. Barchetti.
Good morning. How are you?
I am wonderful. How are you?
Very good. Can't complain.
If not seen your other side yet, my policy is 15 minutes after the scheduled start time. So if they're not here by about 9:45, I'll call your case, okay?
Sounds good. Thank you, Your Honor.
Thank you. Mr. Hill, were you expecting Mr. Rogers to come out?
Yes, I am.
We'll try to give him a little nudge.
I'm having my own technical problems.
I'm trying to get him here, Judge.
Thank you. This is 231454 GC Midland Credit Management versus Terry Rogers. May I have your appearances, please?
Morning, Your Honor. For the record, William Hill, P. 28608, appearing as coverage counsel for Midland Credit.
Good morning, Your Honor. Terry Rogers.
Good morning, gentlemen. Today is the day and time set for the adjourned pretrial and hearing on the plaintiff's motion. You've had the opportunity to speak. Mr. Hill, how are we proceeding this morning?
Your Honor, I'm covering this case and I have the plaintiff's motion for summary disposition. Mr. Rogers indicates that he filed a response to this and attached exhibits to it, which I do not have and I haven't seen. Accordingly, he says he mailed it into the court. I assume that the court has it.
What the court received was a Bank of America statement that shows a payment of $3,421.28 to the community on June the 21st, 2022, but it does not show an account number. And I know this was a conversation we'd had during a previous hearing. Mr. Rogers attached to his answer, I think it was a print screen from, you have to help me, Mr. Rogers. I think it was the print screen from the bank previously.
Yeah, the first one was from my phone, so I figured that wasn't good enough. So I went to the bank and had them print this out.
What's confusing to me is they're showing that this was charged off in March of 22. All right, and community wouldn't have accepted any payments after it was charged off. But I don't have the answer. I don't have the documents in front of me. It's been adjourned once before, as I understand it. Is that correct?
That's correct.
We're showing Midland purchases on April 26th of 2022. It was charged off on March 31 of 22. So if his payment went to Comenity in June of 22, that would have been after the purchase date.
Correct. And Mr. Rogers, the issue is that the bank statement does not show the account that this was applied to. It's possible that a person had more than one community account. So did you have anything that confirmed the account that this was applied to?
No, the young lady I talked to, I was handling, the young lady I talked to, the representatives told me this was clearing all my debt with community that I had. That was her exact words.
And so that payment was for
$421.28.
what?
And it shows as a web-based payment on June the 21st, 2022. And Mr. Rogers did attach this, well, a screenshot of this information to his answer that was filed back on September the 29th. So this information about the payment has been out there.
Okay.
The question has been, the issue has been showing that this is for the account that's at issue in this case, an account that ends in number 7338. So Mr. Hill, how would you like to proceed this morning?
Well, Your Honor, They did not give me a copy of his answer. Obviously, they must have been made aware of it, but they weren't satisfied. They filed a C-10 motion on no genuine issue of material fact. There may be an issue of material fact. I don't have any. I don't have any other documentation other than what's been submitted to you. Okay, in support of the motion for summary disposition. Perhaps we could revisit this in 30 days. Would that be acceptable? I'd like to see a copy of this shot, because it doesn't seem to make sense that an account would be charged off and then a payment would be made.
Mr. Hill, I'm just looking in the on-base system to see if it's in the on-base system. So, Mr. Rogers, when you supplied this copy of the bank statement to the court, did you send a copy to the plaintiff's office?
Yes, ma'am. You're the lady who took it from me. Make sure she said that to me again. You want to make sure you send them a copy, and that's what I did as soon as I left. So whatever date that I submitted it to the court is the same date I sent them a copy.
That would have been on October the 24th.
Okay.
So, Mr. Hill, if you're able, before we adjourn the matter again, if you're able to get a hold of someone at the law firm to confirm receipt of this document and maybe updated directive from them on how to respond this morning, only because this case has been adjourned multiple times. Mr. Rogers has always appeared. The issue has been, he's been consistent in his defense to this matter.
Okay.
Okay, so we'll pass the matter briefly. Mr. Rogers, if you'd sit tight, we'll come back to you in just a moment, okay?
All right. May I log back in, Your Honor? Is it possible?
Absolutely, sir.
Okay, thank you.
Good morning, Mr. Collins.
Good morning, Your Honor. How are you today?
I am wonderful. How are you?
I am suffering from post-bar mitzvah weekend fallout.
Did you receive an email from Mr. Brown with some documents attached from Humana?
I can't say that I did, but I'll double check.
Double check. He's not here yet. The case isn't scheduled until 9:30, but I wanted you to be aware that there had been documents received by the court. It appears maybe late yesterday.
No, I don't have anything, but you know, again, I'm you know, from my position, it wouldn't matter regardless, but I appreciate it, but
I understand.
Yeah.
Mr. Cox, were you expecting Ms. Hildreth to come out?
Yes, she left before I did.
Here she is now. This is 231362 GC, City of Southfield versus Denise Hildreth. May I have your appearances, please?
Yeah, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
State your name for me, please, ma'am.
Denise Hildreth.
Thank you. Today is the day and time set for the adjourned pretrial and the plaintiff's motion for summary disposition. The parties have had the opportunity to speak. Mr. Cox, how are we proceeding this morning?
Judge, we did speak, and we've been, I think, in some communication over the past month and a half or so. We've not reached a resolution on the case, and plaintiff needs to proceed with its motion this morning.
Ms. Hildreth, is that your understanding of the status of the matter?
No, Your Honor. Immediately following our last court case, I reached out to the plaintiff and the plaintiff's attorney to make a reasonable settlement for this 2019 medical emergency debt to the City of Southfield. The debt is in the amount of $530, and I offered the plaintiff and the plaintiff's attorney $400.
Ma'am, no. The court doesn't get involved in the settlement.
Because that's not the understanding.
Your
Because we have
understanding is
two
that you
different
don't have,
understandings.
ma'am. What he said is that there's not an agreement this morning and plaintiff wants to proceed with the motion.
They're proceeding with a motion for
summary
what is the motion?
disposition.
Okay. As long as because he kept saying to me that he wanted to proceed with a motion to have a judgment placed against me, and that's what I'm not in agreement with.
You're not in agreement because you offered a settlement. Let's not talk about the amount, but because you offered a settlement, you are objecting to entry of a judgment.
Yes,
Is that what you're
ma'am.
saying? Okay.
Yes.
I understand, ma'am, but the court can't force a settlement. If the parties have spoken and can't come to an agreement between themselves, Mr. Cox's office filed their motion for summary disposition. The court has received it and reviewed it, and they have an absolute right to present that motion.
Okay.
So you might not agree with how the case is proceeding, but what Mr. Cox said is accurate, that there's not a resolution and he wants to proceed with this motion.
Okay, the reason for the non-resolution is not that they don't want my money, is that they want me to fill out a financial hardship documentation to disclose in open court all of my personal information, affairs, finances. And he said if they were to take a look, then maybe they would take the settlement. But isn't that my right to privacy being violated? Because I'll pay the $530. But the attorney keeps threatening me with the court costs. This is a medical emergency. I don't owe a creditor. And I'm being treated as though I owe a creditor.
Ms. Hildreth, the document that I believe that you're referring to for Mr. Cox is not something that will be filed in court. It's some agreement between the parties. So at this time, if there's no agreement between the parties, the court will allow Mr. Cox to present his motion.
Okay.
Mr. Cox.
Very good. Thank you, Judge. We brought the motion this morning pursuant to MCR 2.116C9 and C10. We don't believe there are questions of material fact or valid legal defenses that warrant the case proceeding past today. This was for a case, a very straightforward collection case for an unpaid ambulance bill. The motion sets forth the destination, or the location the defendant was transported to, where she was transported to. We attached an account stated setting forth the breakdown of the costs for the various services as rendered. We also, at the time that the services were provided, were given some insurance information, priority health. We attached an explanation of benefits relative to the billing that was undertaken to attempt to get paid to collect from a third party that ultimately was denied, or no payment was received from priority health, indicating it was a patient responsibility. I would also note that we did provide in the defendant's copy of our motion the full run report for the services that were rendered, that was created, that effectively the medical record created at the time that the services were done. We only provided a short portion of that for the court because we redacted one page of it just to evidence the fact that it exists, and that we could also present that, I suppose, on a screen share if it was required. But I don't know that there's really a question of fact that the services were rendered as set forth in our motion. This seems to be more a matter of either her belief that insurance should have paid more of this on her behalf, or that this should have resolved in some other fashion. But we don't believe the existence of insurance per se is a valid legal defense, and neither is the idea that she was willing to pay some amount less than what's owed. So at this point, we believe, based on what's before the court, that summary disposition is appropriate for the amount paid for in our complaint.
Thank you. Ms. Hildreth, the court did not receive a written response to plaintiff's motion, but you may present a defense to the motion if you wish at this time.
I'll just complete the paperwork because I don't know what else to do. I'm trying my hardest to just pay this debt, and they're not being reasonable. I'll just complete the paperwork and fax it over. I have nothing else to give. I literally don't have the funds.
Your Honor, may I make a suggestion? She's made a settlement offer that is contingent upon her completing a financial assistance form for the city of Southfield to review. I would advocate that the court grant the plaintiff's motion today, and perhaps refrain from signing the order that we had previously submitted. And if the defendant complies, and perhaps give us a 30-day window to submit that order to the court. If the defendant completes the financial assistance package we accept and she makes the payoff, we would then file a dismissal rather than the order for summary disposition. And if she fails to do that, or my client doesn't want to grant her that, then we would submit the order, since the court would have already granted our motion. if the court's inclined to do so this morning.
Mr. Cox, what the court is inclined to do, based on the statements just made by Ms. Hildreth, is to grant the motion for summary disposition and sign the order that has been presented to the court. If the parties reach a different resolution that includes a setting aside of that order, that's something that you
Okay.
take up with Ms. Hildreth and you submit it to the court by stipulation. The court would, of course, enter it and undo what has been done this morning. But Ms. Hildreth, the court has offered you the opportunity to present a defense. You've indicated that you wish to proceed in a different way. The plaintiff's motion was complete, and the court will grant the motion for summary disposition, the amount prayed for, which is $530.20. Plaintiff is entitled to recovery of all court costs and statutory attorney fee. There's already a proposed order submitted to the court. The court will sign that. If you wish to be in contact and communication with Mr. Cox's office and provide the completed hardship information that was requested previously, that's some conversation you have with that office. And if there's a subsequent document that removes the judgment or entry of judgment from the file and replaces it with a different settlement agreement, the court will sign it once it's presented. Is there anything else, Mr. Cox?
No, Your Honor. I appreciate the court's time.
Anything else, Ms. Hildreth?
No.
Thank you. That concludes this matter. Have a good day.
Thank you, Judge.
Mr. Berta? This
Yes,
is
ma'am.
2300403 GC Portfolio Recovery versus Wendy Leach.
Good morning, Your Honor. Suzanne Barta, P 65425, on behalf of the plaintiff.
Thank you. Today was the day and time scheduled for the first pretrial in this matter. It was scheduled at 9:30. It's now 9:45 by this court's clock. The defendant having failed to appear, sir, how would you like to proceed this morning?
Your Honor, plaintiff would like to submit a default judgment at this time.
Absolutely, Mr. Barter. The plaintiff's request for default judgment is granted. Please submit it by on base. The court shows principal damages of $684.86. You're of course entitled to recovery of your court costs and statutory attorney fees. Is there anything else this morning?
Not at this time, Your Honor. Have a wonderful day.
You too. Thank you, sir.
Thank you, Your Honor.
Mr. Rogers, I'm not sure what happened with Mr. Hill. I thought that his contact with the law firm would be quick and he would be right back. If you give me just one moment, please.
Okay, Your Honor.
Mr. Collis, this is 225471 GC Forest Health Medical versus Andrew Brown.
For the record, Your Honor, Stuart Collis P 49530 on behalf of the plaintiff.
Thank you. Today was the day and time scheduled for hearing on the plaintiff's motion for summary disposition, as well as it being the court's fifth pretrial in this matter. Case was scheduled at 9:30. It is now 9:46 by this court's clock. Mr. Brown has failed to appear this morning. How would you like to proceed, Mr. Collis?
Your Honor, this time we ask that the court grant our motion for summary disposition. As far as I'm aware, there has not been an answer filed by Mr. Brown. I do understand that apparently he may have emailed the court some documents for Humana, but I don't think that determines anything, because at the end of the day, if he has a dispute with his insurance company, that's between him and his insurance company. We have no contract with Humana at all. So being that there is no defense, being that Mr. Brown is not here, we just ask that summary disposition be granted. Principal amount of damages $4,259.18. Court costs of $209.68. Statutory attorney fee $75 for a total of $4,543.86.
Thank you. Defendant having failed to appear, having failed to file a response to the plaintiff's motion for summary disposition, that motion is hereby granted. Total judgment of $4,543.86. Mr. Collis, was there a proposed judgment attached to your motion?
There was not, Your Honor. I was just going to e-file it. I didn't know how the court wanted that handled.
Would you please e-file it? The court will sign and get it out to the parties.
Thank you very much, Your Honor.
Thank you, sir. Have a good day.
You too.
This is a recall of 231454 GC Midland Credit versus Rogers. Mr. Hill, were you able to get an answer regarding this payment?
Your Honor, they are not showing that. I spoke to the attorney in charge of the record. They don't have a copy of the response filed by him, by Mr. Rogers. They've asked me to ascertain if there's a copy of the front and back of this check. Was it ever negotiated? What account was it applied to? They're not showing anything. If it has been negotiated, we can go to Comenity and straighten it out. They've asked me for Mr. Rogers to provide a copy of the front and back of the check. If that's
Mr.
possible.
Hill, it's not a check. Mr. Rogers, if I'm reading the statement correctly, it was a web-based payment?
Yes, yes, it came directly out my account.
See, this would have been
Mr. Rogers, do you object to this matter being adjourned?
Yes, because I mean, the guy said I didn't send anything, and here it is. I went through everything, ran to the bank to get all the stuff, and I brought it. I even brought you a copy to make sure it was nobody say you didn't get nothing, and now they're saying they still didn't get it. That's 2 times I sent it to that company.
Okay, Mr. Rogers, do you have a proof of service or proof of mailing that you sent that statement? I know, Mr. Rogers, there are rules that have to be followed when documents are served. Okay. And the way that the court received it was just attached to the e-file. I can't tell from looking in the file that you served a copy on them. Okay. And the same thing with them. If they tell me that they sent you something and you say you didn't receive it, if they don't have a proof of service, then I would make them serve it again. Okay. So how did you send it to them the first time?
I sent it by mail to their PO address.
Did you include a cover letter of some sort?
As soon as I left here, I just wrote I just attached, I attached the paper that they sent with my name and all that stuff on it and sent it. Soon as I left the court.
Mr. Hill, I understand that you are just coverage attorney in this matter, but if Mr. Rogers sent it directly to you, is that best, or is there someone specific he should address it to at the firm?
Yes, he should address it to Mr. Andrew Perry, who is the attorney of record. I spoke with Mr. Perry. He was in another hearing right now. Now, Mr. Rogers may have already spoken with him, Perry says, we're not showing that a receipt of a response to the motion for summary disposition. We're not showing a copy of this. He may have sent it, okay? If he sent it on October 24, all right, maybe they didn't process it. But they're saying they have notes in their file to ask Mr. Rogers for verification of the payment, front and back of the check. If it's a web-based payment, there wouldn't be a check. I understand that. So I don't have anything associating the payment with that particular account. He may be right. Mr. Rogers may very well be right. They've asked me to ask for an adjournment on this so we can investigate it. It's just unusual for us to purchase the account, okay, and have a payment accepted by Comenity 2 months after the account was charged off. Or 3 months after. It was charged off March 31 of 22. That account
Mr. Rogers, I hear your frustration. I appreciate it. The court will adjourn this motion, this pretrial one last time with a return date of December 5th. Mr. Rogers, at 9:30 a.m., is that a good date for you? Good date and time?
9:30. Yes, Your Honor, that's fine.
Thank you. We'll
Mr.
put this
Rogers-
matter over to December 5th at 9:30 a.m. I'm sorry, you were saying something, Mr. Hill?
Yes, I can feel Mr. Rogers' frustration on this. Do we have your email on this, Mr. Rogers? May Mr. Perry email you back and forth to facilitate this? Because if you've got proof of it, we'll dismiss. We'll get it straightened out. Do we have an email for you, Mr. Rogers?
I don't know. So you saying they didn't even receive the first proof, and I sent that like what five. When did this start? Like maybe I sent that like 4 or 5 months ago. So they didn't even receive that proof neither then, huh?
They're showing that they have not received a response to your motion or their motion for summary disposition. All right. And I understand.
Mr. Rogers, if I'm understanding Mr. Hill correctly, Mr. Perry is indicating that he did not receive what you left with the court on October 24th. What I'm going to have you do is go back into a breakout room with Mr. Hill, provide your email address to make sure that Mr. Perry is in contact with you and that the statement you left with the court on October 24th reaches them before December 5th.
Okay.
Okay?
Okay.
That's not, I don't know that Mr. Hill is indicating that Mr. Perry didn't receive the September 29th document. He's saying he didn't receive the October 24th document.
Right.
But I'm saying, okay, yeah.
Thank you, Your Honor.
Anything else, Mr. Hill?
No, Your Honor. Once we finish with the breakout room, can we just leave and then come back on the 5th?
Absolutely. Anything else, Mr. Rogers, before you go back in to give the email to Mr. Hill?
No, Your Honor.
Thank you, Mr. Rogers. You have a good day, sir.
Thank you, Your Honor.
Your Honor.
This,
Do
yes,
I need to bring anything else back to the court? Because I will.
Mr. Rogers, you are free to file whatever you want to file in this matter. Just make sure that anything you serve the court, you serve the plaintiff's attorney with, and you attach the proof of service or make some other kind of confirmation, email, green card or proof of mailing or something so that we didn't receive it doesn't become an issue again.
Yes, Your Honor.
Okay, go in and give the email address to Mr. Hill. Thank you for your patience this morning.
All right, thank you.
Okay,
This is 230030GC LVNV versus Garaba. May I have your appearances, please?
Yes, good morning, Your Honor. For the record, Paul Varchetti appearing on behalf of the plaintiff, LVNV Funding. My P number is P49403.
Garaba,
Yes, I'm here. I'm present.
turn your video on and state your name for the record.
Hi, yes, my name is Kudokwasha Gerald Garaba.
Thank you. Today is the day and time set for the first pretrial. Mr. Varchetti, how are we proceeding this morning?
Yes, we've had the opportunity to speak. We could not resolve it. We would like 30 days of discovery, at which time we'll file a motion for summary disposition, Your Honor.
30 days of discovery will commence immediately. To allow time for the filing, for the completion of discovery and the filing of the motion, let's adjourn the pretrial / motion date to January the 2nd, 2024 at 9:15 a.m. That will be back here in Zoom in courtroom number 1. Notice will be mailed to the parties. Mr. Garaba, you will receive written requests for information from the plaintiff's office. Respond to them in writing and return them. If there's anything you want from the plaintiff, this is your opportunity to send your written request to them for either of those documents or to answer whatever questions you have of them. Okay?
Okay.
Plaintiff's attorney has indicated that they will likely be filing a motion. Anything you receive in writing from them, you need to file a written response to. We will take this matter up again on January the 2nd, 2024 at 9:15 a.m.
Okay.
Anything else on behalf of the plaintiff?
Nothing, Your Honor. Thank you very much.
Anything else on behalf of the defendant?
No.
Thank you, sir. That concludes this matter. I'll see you in January. Have a good day.
All right, you too. Thank you.
Thank you. Ms. Lambert?
Yes, ma'am. Yes, Your Honor.
Ma'am, this case isn't scheduled, and thank you. This case isn't scheduled until 10 o'clock. We're just shy of that. This court allows 15 minutes. So if Mr. Lazar's office is not here by about 10:15, the court will call the case and get you on with your day. I did receive your written response to his motion, okay?
Thank you.
Thank you. Mary Ann, I'm just gonna leave the bench so I can close that file, that Brown matter.
Okay.
The attorney for Pioneer Financial.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Good morning, Mr. Lazar. I wasn't
Oh.
quite calling the case yet. I was asking, did you want to speak to Ms. Lambert before I call the case?
Yo, we're ready to go. We have an issue that we've already discussed, and I guess we need to talk to you.
You don't need to talk to me. You want to talk to me.
I think she wants to, not me.
She's here. This is 233084 GC. This is Pioneer Financial versus Marquetta Lambert. Ma'am, would you turn your video on and state your name for the record, please?
Yeah, okay. Yes, Marquita Lambert.
Ms.
Marquita
Lambert, today's the day and time set for hearing in this matter. Mr. Lazar has indicated there's some issue that the parties might need to discuss with the court.
Your Honor, I could address that further if I may have a moment.
Absolutely.
So the long story short, and I think there's not any real conflict. There's just a discrepancy in some of the language. So I think this will sum it up nicely. Ms. Lambert, I think, will agree. We had a little trouble getting in touch at first. We didn't have apparently the right number for Ms. Lambert. We had an older number. So she called a few times, but she didn't leave a callback number that worked. So we finally got in touch. I had a good number for her. So it delayed the consent judgment a bit. We finally got her the documentation. There was a dispute as to the amount. We had thought it was 100. She wanted 50. I said, no problem. I gave her the 50. It wasn't a big deal. I said, all you got to do is initial, because at this point, it was last week. I said, at this point, do me a favor, just cross out 100, write in 50 and initial over it. We'll initial over it because we got to get it to the court in time. So it came back and she crossed off 6 or 7 other items that had not been discussed and made changes. A lot of it was just courtesies, like a grace period that we never even discussed. It was your due date is this date, but I put in a 3-day grace period to be, courteous, which is what our client allows. She crossed that off for a different number. There was just too many changes, and I can't get it approved when we're already starting with the fact that they wanted $100 that they thought was the agreement. I just waived it and did the 50. I got approval from, Mr. Rich, to try to make this easy. But then when I got the agreement back with 7 or 8 other changes, I can't get that approved. So we have I think the best way to put it is we actually have an agreement to the judgment. We have an agreement to the amount per month. The only issue here is little details that are in our order. So I don't know if Your Honor would like to I don't know if Your Honor has a judgment there we can fill out. I don't know if we want to just do this and do a 7-day. I leave it to you, Your Honor. We have 90% of an agreement complete, but I can't get all these changes approved when we've already started at $50 less a month than what they had thought this was going to be.
Okay, I apologize, but number one, I have had the same phone number and they have been calling me previously. I have consented to everything. We never discussed 100. You asked me, how much could you pay? I said 25. You said I can accept 50. When I got the paperwork, it said a 50 down payment and 100 a month. We never discussed that. We never discussed payment immediately. If you miss one payment, you got to pay it all plus interest. That was never discussed. So I agree with you. These things that I crossed off or that I asked for adjustments to, we had never previously discussed. We never did previously discuss any of those things. And they're extremely steamroll me. It's like, you can't miss one payment. All kinds of things could happen. Who would agree to that? Who could agree to not being able to come back and reassess, say, hey, I had an issue. Can I get back on track with you? So, like you said, what we agreed on was I offered 25, you said 50, 100 never was in our conversation. So, and as far as I did try to reach out to you, and again, when we finally got the response, I responded to you saying the information. But the things that I did change, if you look at what I really truly changed, it was those things that was adding up to $100 a month.
Mr. Lazar, before you respond any further, the court did receive yesterday a document that is titled, well, it's labeled from the court staff as the defendant's response to your motion. And attached to that is at least part of the proposed settlement agreement, proposed consent judgment with the mark-throughs from Ms. Lambert. And I was going to advise Ms. Lambert that the court does not get involved in those type of settlements. If there's an agreement placed on the record and you followed up with the 7-day with those terms, the court will enter it. But Ms. Lambert, the court does not typically get involved in helping the parties hash out the language of their settlement agreements. If it's your understanding and agreement this morning, ma'am, that we are starting with the full balance that's due and owing and that you'll pay $50 per month on a set date, the court is happy to enter a judgment in that amount. Mr. Lazar, am I excluding too much other language?
Again, Your Honor, I'm not sure how to respond because she seems to want to get a little bit aggressive here where I didn't think we were going that route. I thought we were fine.
Aggressive.
I just think, well, some of the things you said there. The thing is, Your Honor, this is the language in that order is pretty standard. Again, if you don't make payments, there's always default language. That's standard in these orders. So when she says, I don't know who would sign that, these are how these orders always read every time we enter them. So again, I don't have any authority to enter an agreement that doesn't have default language upon a missed payment. I don't know what else to say to that.
I don't know what you heard, but I'm saying I don't understand why do the language say if you miss one payment, you have to pay it all plus interest. I don't think that's fair. I think I should be able to get a chance to get a reset if there's a legitimate reason. If I was in the hospital or something, if something happens, I feel like I should be able to come to you as a creditor and say, hey, something has happened. I'm sorry I missed that payment. Can I get reestablished with you? Can we get this back on track?
You can call us and tell us, and there's remedies through the court, though. That's the thing.
I don't understand all of that. I'm not a lawyer. All I just know is when I got the paperwork saying if you miss one payment, when I know a lot of things can happen in life, you have to pay it all. I'm just being honest. I'm fearful to sign that because that binds me to that. And if something happened, it sounds like you don't have to hear anything else from me. We cannot.
Well, Ms. Lambert, I'm interrupting to ask you a question because I don't know that the court received the settlement agreement in its entirety. Was there a reduced amount agreed to?
No.
There was not, Your Honor.
Oh.
That's why I don't understand.
So if the court enters a consent judgment for $2,126.24, which is the principal damages plus court costs plus the statutory attorney fee, and sets in that consent judgment a payment plan of $50 per month beginning on November the 5th, well, we already passed November the 5th. Beginning at an agreed upon date within the next week or two. And then in lieu of this language that seems to be problematic for her, Mr. Lazar, your office then would have to file a motion to set aside payments or affidavit of non-compliance to set aside the payment terms. Would that be more palatable, Ms. Lambert, than automatically?
Your Honor, I do believe the affidavit of non-compliance language. Again, I don't think she understands. There's nothing unusual about that order. There is affidavit of non-compliance language in there.
Ms. Lambert, what is your issue with how this reads?
So the way I understand it, if I miss one payment, I have to pay them whatever the full amount is plus interest immediately is what the paper says.
It says it will come due. It doesn't mean that you have to pay it. It means that it's now due. Inherent in that is that they no longer have to honor your $50 per month payments. So there's a consequence for failing to maintain the payments, meaning they don't have to continue on at that rate.
Okay, Well,
It's not
I-
that you immediately owe the full well, you owe the full balance, but you don't have to pay the $2,000 or whatever remains in one single payment, but it becomes due and they can do other things to collect the money rather than wait for you to resume a $50 a month payment.
Pretty much 4 out of these 5 issues are non-issues.
I apologize.
So pretty much, other than the grace period, which we can, figure out, again, the amount due is the same regardless. The affidavit of non-compliance that gives you the chance is in there. That's why I didn't know what else to do other than appear in front of Your Honor. I wasn't trying to be difficult, but again, I know she doesn't understand this order, but the things she's saying are already in there.
So all I requested, my concern was to sign a paper saying if for some reason I miss it, that they will not talk to me anymore or give me a chance to well, that's how I felt. That's what I experienced when I read it. When I read it, that's what those words meant to me. And
well,
so I don't
Ms.
know.
Lambert, I'm reading it right now, and it indicates that there's they said 3-day grace period. You crossed it out, put 5-day grace period. The proposed order also indicates that if any payment is not received, then the total balance pledged in the suit will become due, plus interest which shall accrue from the filing date, less any payments that you've made. That's standard language. That's not unusual, and it doesn't mean that you have to write a check for the balance. It means that they will not honor the payment plan going forward. It doesn't mean that you can't talk to them. It doesn't mean that you can't try to reestablish a payment plan, but if the parties put in language for every possible issue that might come up, the document goes from being a page and a half long to being 20 pages long.
I understand.
Okay.
As long as the way you just explained it, that's how it's going, then I'm fine. I just did not want to agree that if something came up and I missed a payment, that I had to pay them $2,000 plus interest immediately. That was my concern.
Oh. Okay. Mr. Lazar?
Yes, Your Honor.
So that being the case, do you want to resubmit the proposed document to Ms. Lambert? Or do you want to just file it as a 7-day?
I do have just one question. I'm sorry. On the 5th,
yes,
my
ma'am.
rent is due. I'm sorry. I live check to check. So I just would like to ask for the payment to be due. I do have the money order now for good faith because I thought it had to be in by the 5th. I have the money order for the $50. But can the future payments be due on a later date, like the 15th? Again, I'm sorry. I live check to check. And if I pay my rent on the 5th, it's a possibility I may not have the $50.
Mr. Lazar?
Yeah, I don't think that's the problem. I just want to make sure I'm still trying to answer Your Honor's question as to how we do the order. I apologize. I was listening. I just didn't respond. I was reading. I apologize, Your Honor. The date will not be a problem. I'm just still trying to get back to what you had asked, Your Honor. All right, so should we read? I guess I'm trying to think. I would prefer, I guess, either doing an order on the record or a 7-day. So should we read through to make sure we're on the same page?
I'm sorry, it blanked out on my end.
You cut out for a second.
Sorry about that. Should I read? It's probably because I'm going through 3 different programs at once. Can we read through this order for the 7-day? I'm reluctant to do another sending of the order. and to have return and then have another court date. I'd rather just do a 7-day if we could.
That's fine.
So the
Miss-
terms on, sorry. So I do believe the terms on the first page and the last page, there's 3 pages, are unchanged. So those are the same as they were. It's only the second page that has changes. So is that okay if we just go through that?
That's fine, Mr. Lazar. That's all the court has. The court has the middle page that starts with payable and 53 payments. It ends with this court signature. So Ms. Lambert, you didn't make any changes to the first page or the third page?
No, ma'am, I didn't make any changes to anything except for those things that made it equal to more than $50 per month and the days. I was in agreement with just going on with the settlement.
So Mr. Lazar, if you want to go over the second page right now and then submit it 7-day.
So the cross off of payable in 53, okay, so this is going to get complicated. I don't have the number of payments without recalculating the, I do believe it to be 55 payments, but now I don't want to say the wrong thing without, this is going to be messy no matter how we do it. So I don't know how else to say this other than the number of payments have to match the balance due. And the number of payments change anyway, because if there's any missed payments, regardless of if we allow it or don't allow it, it's going to change the number of payments via the interest accruing. So can we just waive the amount of payments? It's going to equal the balance. I don't know how to say that on the record for a 7-day because I don't know right now how many payments it's going to be. And that's one of the things she crossed off. So does she want to waive that, or should I just send her?
I was just concerned that if
No,
I signed the
understand.
paper.
I'm trying to make sure for the, Your Honor understands. I'm trying to make sure I don't want to say the wrong thing for a 7-day order. That's the problem.
Are you waiving interest if she's making these $50 per month
No,
payments?
there's still the 13%.
No, okay.
That's the whole, there's still the 13% interest as paid for in the
Okay.
suit regardless.
So the order should just say that Ms. Lambert, that you will pay the principal amount, the 2126.24 plus court costs plus statutory attorney fee, and any interest that has accrued from the filing date forward. And Mr. Lazar, in his proposed order to the court, can put what that total is as of the date he submits it. It will indicate that you'll make payment of $50 per month beginning on November the 15th and $50 per month on the 15th of each month until the balance is paid in full. So then we don't get into this calculation of payments because things might happen. They change it from 53 payments to some other payments if you pay more 1 month or something like that.
Yes, ma'am.
Then it's
Yes,
further
ma'am.
ordered that you may prepay any amounts due hereunder without penalty or premium. And if any payment is not received, then the total balance pled and that amount will immediately come due, plus interest shall accrue from June 22nd, 2023, less credit for any payments made prior to the default. It is further ordered that the defendant will have a 5-day grace period in which to make each payment described in this consent judgment from the due date without penalty. Those are the only things that were changed on that second page. Was that your understanding, Mr. Lazar?
Yes.
Is that your understanding and agreement, Ms. Lambert?
Yes, ma'am. Yes, Your Honor.
So what will happen now is Mr. Lazar's office will file with the court a proposed consent judgment that has the terms that were just read into the record. Additionally, it'll be the first and third pages that both parties have agreed there were no changes to and that you agreed to.
Wait, I'm sorry, Your Honor.
He will file it with the court.
I think I misunderstood what's going on. I got to use the original terms. I can't use the terms she put in.
What
I thought
original
that's-
terms?
Like instead of the amount shall, and she wrote in upon reassessment, it's got to say shall immediately.
No, I read shall immediately.
Oh, I'm sorry. You did do the original terms. I just want to make,
Correct.
again, these 7-day orders drive me nuts. I'm sorry. I just want to make sure.
No. We're on the same page, Mr. Lazar. And Ms. Lambert, what I was starting to say is Mr. Lazar his office will file it with the court electronically. You will get a copy as well. when you get that document, if you don't think it says what we just placed on the record, you have the opportunity to respond. If Mr. Lazar's proposed consent judgment says what we just placed on the record, and you agree, you don't have to do anything, the court staff will send it upstairs to me, I'll sign it, you'll get a copy in the mail. Okay?
Yes, Your Honor.
Is that reasonable, Ms. Lambert?
Yes, again,
Yeah.
I told you the only thing I was concerned about, I was actually scared that if I signed something, say immediately, that I knew I wanted to be able to at least keep the line of communication open. I'm really, again, that was that.
Ms. Lambert, I understand completely. I did this kind of work for a long time, and what happens is we get so used to the language, we forget what it sounds like to most regular people who don't see it all day, every day.
Thank you.
And Ms. Lambert, again, I don't know if you forgot, but I have a note right here. I have it in our system. We changed your phone number. We had a different phone number on October 23rd. We've talked a few times since then, so I have no trouble talking. You're always welcome to call. I don't know what the discrepancy is here, but on 10/23, we changed your number from a previous number that the last four was 6594 to your new number. And we've talked since then. So I'm always happy. Always feel free to call. There should not be any reason for us not to communicate going forward.
Okay. I don't have a problem.
I think we're all on the same page now, Mr. Lazar. The court will await receipt of your proposed order. Is there anything else, Mr. Lazar?
That is it, Your Honor. Apologies for all this, and thank you for your help and your time.
No worries. Anything else, Ms. Lambert?
No, thank you, Your Honor.
You're so very welcome. That concludes this matter. You have a wonderful day.
Have a good day, everybody. Be safe.
Thank you. And Mary Ann, that concludes our docket for the day. We stand adjourned.
Hey, good job on that.
Thank you.